Okay, so we only have a few more videos. If you're watching these out of order, you're like, what? Anyway. Okay, buyers and sellers remedies under the UCC. And it also says reliance damages. We'll see if those go here or not. So buyers and sellers when they breach. When sellers are breaching, it's for non-conforming goods or failure to tender. So this could be too few, too many, wrong time. And when buyers are breaching, there is a refusal to accept goods. So UCC 2712, because UCC always covers goods, and where the UCC is silent, we follow common law. UCC 2712 says is about covering. So buyer's procurement of substitute goods. The covering purchase must be cost between the contract price and the replacement price, made in good faith and without reasonable delay, and it must be a commercially reasonable substitute. When buyer covers, damages are the difference between the cost of cover and the contract price, plus any incidental or consequential damages, so costs incurred because of the breach of contract, and like if you need to pay a middleman to get them, or if you needed to pay for storage for them, either one. Less expenses saved in consequence of the seller's breach. So if you saved any money because of the breach, then that is also taken off the total. Buyer is not required to make covering purchase, but it is the only way to get consequential damages, because those are money that is paid because of covering. So you won't have consequential damages. But failure to cover means that buyer cannot collect consequential damages. I just said that. Mitigation of damages principle. So yeah, you've got to mitigate if you want those extra costs. UCC 2713 says buyer damages for non-delivery or repudiation. If seller does not cover, then damages are the difference between the market price at the time when buyer learned of the breach and the contract price. So that's if they did not cover. Market price is the place for tender, and the place of tender depends on where the seller completes its delivery obligations, or is supposed to, with respect to the goods. Exam question, can a buyer forego cover damages and collect market price damages? Imagine the buyer covers at a price below the market price. Most commentators agree that recovery is limited to cover damages. And 2713 goes on to buyer's damages for non-delivery or repudiation. So it continues. In the case of anticipatory repudiations, when do we calculate the market price? That's a great question. We have three options. We have the date when buyer learns of the repudiation. We have the date when the buyer learns of the repudiation plus a commercially reasonable time thereafter. And we have the date when actual performance by seller is due under the contract. UCC 2714, buyer's damages for breach in regard to accepted goods. What if buyer accepts the goods but isn't satisfied? First, the buyer needs to give notification to the seller. Second, the measure of damages for breach of warranty is the difference at the time and place of acceptance between the value of the goods accepted and the value they would have had if they had been as warranted, unless special circumstances show approximate damages of a different amount. Third, the buyer can, under appropriate circumstances, collect any incidental or consequential damages. So that is when they accept. They need to notify the seller. They can get the measure of damages for the breach. So what the difference would be. And they can collect incidental and consequential damages for, which is basically like covering Buyer's right to specific performance 2716. The UCC is far more liberal regarding cases where specific performance can be granted. The common law typically requires money damages to be inadequate before they'll try specific damages, and this would be when goods are unique. Therefore, under the UCC, specific performance may be decreed where the goods are unique or in other proper circumstances. If goods are readily available on the market, a court applying the UCC is likely to deny specific performance because they don't like to tell people how they need to serve others. UCC 2715, buyer's incidental and consequential damages. A buyer's damages include incidental and consequential damages. Great. Incidental damages consist of out-of-pocket expenses incurred by the buyer to deal with the consequences of the seller's breach. Consequential damages, any loss resulting from general or particular requirements and needs of which the seller at the time of contracting had reason to know and which could not reasonably be prevented by cover or otherwise. An injury to person or property proximately resulting from any breach or warranty. So if you get hurt by a product because it breached its warranty of good faith, well, you look at that, you look at it too. Resale damages 2706. A buyer breaches, seller may resell goods and recover the difference between the resale price and the contract price. To do so, the seller must follow 3 steps. 1. First, the seller must identify the goods being resold as the same ones under the contract that was breached. Second, the seller must give the buyer proper notice of resale. Third, the seller's resale must be made in good faith and in a commercially reasonable manner. And subsection 1 says, no sham resale to a friendly purchaser or an affiliated entity for a cheaper price. However, just because in hindsight the seller could have gotten a better price does not make the sale unreasonable. 2708 says market damages. Seller may also collect damages based upon the market prices of the goods. This would be contract price minus market value. Contract price minus market value. What happens if the market value is less than the resale price? Can the seller collect based upon market value? Imagine if the seller simply chose not to notify the buyer. The UCC indicates that the seller can collect based upon market value, but courts and scholars are split. So they are going to want you to do resale. So basically you try to resell, and then you get you sue for the difference. But sometimes market damages are going to be better. But in that case, even the UCC says you can go market value, but courts and scholars don't always agree. And if the court doesn't agree, it doesn't matter what the UCC says, right? 2708 subsection 2. Lost profits. Seller can collect lost profits to sellers if the market measure of damages set forth in 2708 subsection 1 is inadequate to put the seller in as good a position as performance would have done. This happens primarily in 3 cases. The lost of volume seller, which we already know is when they can they can sign another contract, but they could have done both. Seller, the next one is seller who is in the process of assembling a product for sale when the buyer breaches. It might not be commercially reasonable to finish production. For example, if the goods are specialty items without an established market. Excuse me. Or the jobber, which is a middleman who hasn't bought the items he is going to sell. So when it's a string of production. What if lost profits are less than market value damages? Think about a case where a seller spent more money producing the item than its market value. The UCC indicates that the seller can still collect market value damages, but again, Courts and scholars are split. I need to brush up on that. 2709, seller's action for the price. The seller may recover the price of the goods from the buyer as damages in 3 situations. First, if the buyer has accepted the goods. Second, so this is just the seller saying, like, no, you've got to pay me. Second, so first, the buyer accepts the good. Yes, you have to pay me. Second, the seller may recover the price if the goods are damaged after the risk of loss has passed to the buyer. Third, the seller may recover the price and essentially force the goods onto the buyer if the seller is unable to resell the goods with reasonable efforts. This is, for all intents and purposes, specific performance. And it continues to say sellers may also collect incidental damages. These include a variety of out-of-pocket expenses incurred by the seller to deal with the buyer's breach, such as the cost of storage or transportation of goods. No mention of consequential damages. Helfand tried to give us a hypo and he couldn't think of one. So maybe drafters of the UCC were persuaded that sellers rarely suffer consequential damages that would not be compensated by the damage measures discussed above. Some argue that courts can award consequential damages based upon common law principles. 1103B allows the common law to supplement the UCC where this UCC is silent, which we already talked about. I'm going to put nominal damages with our non-recoverable damages in the next video.